Something else you need to know. So we talked about the demographic. What do you need to know about, well, let me go back even further. Remember I asked you at the very beginning. You've now learned or gotten the suspicion that the person you're talking to may have a valid medical malpractice case. What do you do next? So now here's what you do next. Now you're going to come to the client and you're going to say, Mrs. Jones, here's what you need to do next. I'm going to send you off, for example, to Mr. Oginski. I want you to take this book that I have in my office, this book that he wrote, called Secrets of a New York Medical Malpractice Attorney. I want you to read this. And I want you to read it because it will help explain how these cases work. And then I want you to call him or call another attorney you're referring them to. And now they're going to help you understanding whether or not you have a valid basis for a case. But before you make that call to send the case to an attorney who handles this, the real question you have to ask yourself is this a type of case that you can handle on your own? Is this a type of case that you feel comfortable handling from start to finish? And if the answer is yes, then by all means take it and run with it if you think it's a valid case. If, on the other hand, you think, wait a second, I don't do this every single day. Let me send the case out to an experienced attorney who handles these cases on a regular basis. Now, what you're doing is you're doing your client a service, you're doing yourself a service, a good one, and you're also doing a service for the referring attorney, for the attorney you're sending the case to. And what you're doing before you make that call, you have to ask the attorney a couple of things. Here's what you need to know. Did you know what the attorney's fee is in a medical malpractice case? For those of you who don't, you should know in a negligence case, the attorney's fee is 1/3 after the expenses are reimbursed to the law firm. But in a medical malpractice case, the attorney's fees are much less. They're on a sliding scale, and they only start at 30% and go down by 5% as we get more and more money for the client. So that's important for you to understand before sending the client out to an attorney who handles these matters. Why do I say that? Because when you send a case out and refer it to another attorney, what you need to do is to confirm with the attorney in writing, number one, the fact that you're sending the client to him. Number two, your mutual understanding of what the referral arrangement is. And typically what will happen is when you send a case to an attorney who handles medical malpractice cases, the referring fee is a sliding scale of the sliding scale. So for example, if I'm able to recover a 25% attorney's fee, you would then be entitled to a 25% fee of my attorney's fee. If I was able to get 20%, then you would get 20% of my 20%. Now, in order for you to take advantage of getting a referral fee, there are a couple things you need to know, and this is very important. New York law and the court rules say you have to justify that you are entitled to receive a fee. Okay, well, how do you do that? Well, the rules say that you have to show that you have done some level of legal work in order to justify a fee. What exactly does that mean? It means that you have spoken with a client. It means that you communicate with the client on a regular basis. It means you strategize with the trial attorney as the case progresses. It might mean that you have obtained medical records for the client and are now evaluating together with the attorney you referred them to different things. All of those things have been found to be justified in order for you to get and be entitled to that referral fee. Now wait a second. Before you get that referral fee, you may ask yourself, how can I protect myself that I can be sure to get that referral fee? One of the best ways you can be sure of getting that referral fee is by filing an OCA retainer statement that's known as an Office of Court Administration Retainer Statement, which tells the court administration, hey, Attorney Jones has just signed up this client. He's now referred them to Mr. Oginski. Now he's on record as being the referring attorney. Again, before you go ahead and deal with having to file an OCA retainer statement, you should ask the attorney, wait a second, do you do this for me so I don't have to? The good attorneys, when I say good attorneys, the good law firms that do this on a regular basis will do it all for you. So that all you have to do is sign the form that we send you in the mail, drop it in the mail, we get the postcard with your retainer statement number, and you're good to go. Plus, you also get written confirmation from us, the attorney, telling you, okay, Mrs. Jones, we've now signed you up, and now you're on record as being the referring attorney. Here's something else you must do, and this is critical. When talking to your client, and now you tell them, okay, Mrs. Gonzalez, I'm going to send you over to Mr. Oginski or to this other attorney. Here's the book I want you to read in the meantime. By the way, if Mr. Oginski is successful in getting you compensation for your injuries, you should know that there's only one attorney's fee. And you can, if you want, describe what the fee is, or otherwise just say that the attorney will discuss it with them. But you have to ask them this key question. If you are successful, I just want you to be aware that because I'm now referring you to Mr. Oginski, who handles these cases every day, it's okay, and there's one attorney's fee, I will then receive a percentage of Mr. Oginski's attorney's fee. Is that okay with you, Mrs. Jones? And of course they're going to say yes. There's no reason to say no. So it's very important that you acknowledge and get from the client her understanding that you are going to be sharing a fee once you send the case out to the trial attorney. Very, very important. Because you never want to be in the situation where now the case has settled and now you come in trying to assert the fact that you are entitled to a fee, and the client says, the first attorney didn't tell me anything that I'd be sharing a fee. I don't want to give that attorney anything. She didn't do anything. So you have to be very careful and just ask that one question, and you'll always get a positive answer.